Hello. How can it be that a person who is already properly put into a will as an heir can be still disinherited, can still lose his or her share in the estate? Of course, if we are talking about a situation when the testator is apt and still alive, that testator could still simply change the will, and that will be the way. But let's say the will was not changed, and the person was maybe inapt but still alive, or apt but ignorant about what's going on to a certain extent. So by the operation of law, later, when that person passes away, and such an heir is expecting that the money or assets will go his or her way, suddenly it might happen that there is nothing to that person. Of course, if there was some clearly criminal behavior, particularly some attempt on the life of the deceased, or if the legal relationship, a blood relationship, was legally cut due to some of, again, legal or judicial decision, then it's clear that the person does not inherit, at least by virtue of the legal devolution. But what if the person is in the will? Then we're usually looking at the Article 621 and following of the Civil Code of Quebec. And again, some situations are clear when this heir was found to be, let's say, guilty, not in a criminal sense, but it was his or her fault, because that person tried to destroy another later will, or tried to impede, to prohibit the testator to change the will at a certain point. So one way or another, illegally interfered with the process of creating this inheritance. This is more or less clear. But one point is generating issues quite often. This point is about seriously reprehensible behavior, because the idea is quite clear again. If somebody is mentioned in a will, and then that person later starts to behave badly, with serious ingratitude, or just injuring, otherwise bringing damage to that person, what is the extent of that behavior when it becomes seriously reprehensible? Actually, the same question is discussed by the courts with respect to donations, when, in case of this kind of ingratitude, the donation should be returned back. But that's another story. So a person who had signed a will passed away, and there is still this 1-year period when other heirs or potential heirs could decide to bring it up to the attention of the court, some judge, that one of the heirs is potentially unworthy to inherit because he or she committed this seriously reprehensible act against the deceased. Of course, right away, there is a defense that the testator knew and had forgiven this behavior. And sometimes it's obvious, sometimes it might be argued because the person was apt. For example, the person signed the will 10, 15 years before his or her death. So the person knew of this seriously reprehensible behavior and had full opportunity, plenty of opportunities to change the will, but voluntarily, intentionally did not change it. So they had forgiven. Or maybe there is some written or otherwise available evidence to that effect. But what if not? What if the situation is unclear? So some heirs, some other relatives or friends of the deceased think that this particular niece, nephew, sister, brother, neighbor, friend, whoever, who's mentioned in the will, is unworthy, like does not merit to receive whatever is there in the will for that person. Interestingly, that before the Civil Code of Quebec, under the previous code, the Civil Code of Lower Canada, the term was different. It was like a major infraction, sort of. So there was a lot of debate if it meant only some criminal or penal, and therefore established as criminal and penal behavior, or something else. So the Minister of Justice, when introducing the new code, specifically mentioned that the wording was changed so that it would be clear that not only criminal or penal behavior is punished by this particular Article 621. And this, of course, had given a lot of room for the judges, for the courts of different levels to interpret this idea of seriously reprehensible. So what is there? Just to be sure, if you have a similar situation, you have your particular facts and you should show them to your own lawyer to discuss. What I'm telling you now, it's a general information and some examples. But your case, as every case about that, will be, if it comes through the court, it will be treated based on its own facts. And as you can see, and as you could see, there is no exhaustive list of like, this is seriously reprehensible behavior, this is not. There are examples. The more cases, the more examples. That in each particular case, based on the rules and the framework established, the judge will make his or her own decision, of course. So what is known according to the doctrine at this point? First of all, it's clear that the behavior should be like of some sort of unlawful, illegal, or at least like seriously bad, like embezzlement, for example, like fraudulent, like abuse against the deceased, even if it's not in itself a penal infraction or several penal infractions, like if it's not punished by the clear wording of the law, let's put it this way. This act or these acts, which are seriously reprehensible, they should be voluntary. They should be intentional, in the sense that the person would know what she was doing, and it was not like a byproduct of some otherwise benign or caring or good act. It should be in itself an intentional act. If, because this is quite usual, if before the testator's death or after, this heir, who is like potentially unworthy, was behaving badly, but not towards the testator, towards the deceased, him or herself, but towards other people, maybe members of his or her family, friends, children, parents, sisters, brothers, aunts, uncles, colleagues, wherever. So if it was a seriously reprehensible act, but not against the deceased, but some other people who are still alive or maybe already passed away without leaving anything to this particular person. So it's not within the scope of the Article 621. So acts that were done against the deceased and during his or her lifetime. But these are like important limits. If it's not like voluntary, intentional, against the deceased, not during his or her lifetime, and if the acts are not like really bad, let's put it this way, then the Article 621 is not applicable. For example, if somebody knew that another will existed, but that will was not in favor of that person or somebody else like connected to that person, and that person knew about that. So if there was a knowledge of the existence of another will and it was hidden, this information was not delivered, that's a reason to declare somebody unworthy to inherit. Of course, if there is some misappropriation of money, especially when it comes to serious amounts of money, when there is some kind of abusive behavior, financial, psychological, physical, and of course, like serious infractions, then we can talk of declaring somebody unworthy to inherit. One of the quite usual situation where somebody should be very cautious, because when somebody's parent or aunt or uncle or grandmother or grandfather or otherwise like weak and vulnerable person in this period of being weak and vulnerable asked formally with a power of attorney or informally by simply delivering access to the bank account, internet banking, something like that, asked to administer his or her money in favor of that weak and vulnerable person, basically to pay living expenses, medical expenses, to take care of it, actually. And that person having this access and in reality kind of uncontrolled access, because the person who trusted, who asked, probably does not require a monthly report of what was going on. There is a situation when that person might prefer, for example, to take some money for him or herself, maybe thinking that it's just a borrowing because when the person dies, then this money would still go to him or her, or without even this kind of justification. Or sometimes when, again, it's just an example and not always it's about unworthiness to inherit. It's just where somebody should think and be cautious. When somebody, again, old and vulnerable, goes to a long-term care facility but still owns a house, for example, and technically this property should be used to generate income in favor of that person in a long-term care facility, but instead of that, the administrator of the property, the mandatory, like formal or informal, prefers to live there, for example, and thinking that the house will go to to him or her after the death of the owner, would use the owner's money for some major renovation to increase the value of the house and to increase, of course, the quality of life in that house. That might be seen as misappropriation of funds, because if the person is entrusted to manage the funds, the person is entrusted to manage the funds in favor of the owner of the funds and of the assets. And many people thinking that if they're heirs and if the person is already in the long-term care facility, they thinking that this person's money and property is as good as already theirs, they start to treat it this way, and that might open the way to this allegation of seriously reprehensible behavior, and as a result of the conclusion that that person is unworthy to inherit. If to this imaginary fact pattern another act or series of acts are added, like those potential heirs or one potential heir tries to isolate that weak and vulnerable person from information so that that person doesn't know what's going on with his or her finances, or maybe provides wrong information, or otherwise tries to basically embezzle the money, to convince based on incoherent, incomplete, or simply wrong information, tries to just get some money from that person, or force that person to transfer the title to some property, and all that in the situation when the internet access is blocked, just phone is removed, and very often sometimes even like quasi-sincerely talks going on, but using some unfortunately not unusual changes in the elderly person's psychological behavior, that talks just bad-mouthing the rest of the family, that you cannot trust them, that they want something from you, and only me or us who are there for you, or only we take you into, and so forth and so forth. If proven, of course, because in civil litigation, not to mention criminal litigation, the question of evidence is always important. But if something like that is proven, that might again give grounds to declare somebody unworthy to inherit. On the contrary, because again, it's not unusual, on the contrary, some situations which look bad do not constitute this seriously reprehensible behavior, at least in the eyes of the law, in the eyes of the application of the Article 621 of the Civil Code of Quebec. Because again, law does not englobe all the moral issues. It's just what's there in the law. So if somebody did not visit the testator in his or her last days or week or months in the hospital, that's not considered to be like seriously reprehensible. If even contrary to the wishes of that person, somebody did not bring him or her back to his or her home or to their home, and the person died in a hospital or was brought directly from the hospital to some kind of long-term care facility, again, this is not something to be treated as like seriously reprehensible behavior. If somebody just openly, but without isolating the person from everybody else, is trying to influence that person, trying to solicit the money or the change of the will, in itself, it's not a seriously reprehensible behavior. But if this influence is undue influence, or captation in French, then it's another ground to invalidate the will, but not to declare somebody as committing a seriously reprehensible act and therefore unworthy to inherit. Those are like two different approaches, actually. Because if somebody is declared unworthy to inherit, that does not invalidate the will itself. It's just this person is no longer an heir. That's the effect of it. If somebody is mentioned in the will because of loan or whatever kind of friendship, not even necessarily loan, and then, like in the eyes of the common observer, behaved not as a friend, then again, it's not a reason to say that that person is unworthy to inherit. There is, though, an approach, not really confirmed so far, like resolutely, but still there is an approach that if somebody is called a friend in a will, it's possible to try to convince the judge that that was a condition of this legacy, saying that, well, that person receives this money as long as that person is a friend. But the notion of friendship is elusive. So convincing a judge that that was a condition would require the judge to accept at least some tests for friendship and non-friendship. And because that's more of a moral notion than legal notion, well, there might be a problem there. But at least like a broken friendship in itself is not a reason, according to the current case law, it's not a reason to declare somebody unworthy to inherit. If the relationship among the heirs, which happens unfortunately again, is very hostile and some like really bad acts are observed between them, one towards another, it's still, it's bad, of course, but it's still not something that is considered to be seriously reprehensible behavior towards the deceased in his lifetime. And therefore, it's not a reason to declare somebody unworthy to inherit. And again, though it's very sad and bad, but if one of the heirs, maybe the majority of the heirs, or an heir who gets most of the estate, because of that, or based on that, treats badly the spouse of the deceased, his or her children. Sometimes it might be because the text of the will was not seriously thought through, and because the testator thought that that person would take care. But again, what the testator thought, we don't know at this point, so we only usually base it on the text of the will, especially if the text was signed before a notary. So there was a specialist there whose job was to elicit the true intent, or at least reasonably comprehensible intent of the testator. In such a situation, even though we can see that what's going on is probably not the best thing, but it's not, again, the reason this attack or bad treatment of the spouse and children, because there's also always a question of family patrimony also and so forth. This bad treatment in itself is not a reason to declare somebody unworthy to inherit, particularly because it's all happening already after the death of the person. If you're interested in the topic, I can recommend to read some judgments, particularly these three, but there are more of them, so you could start with those and then continue to read those connected, meaning like citing these judgments or judgments that these judgments are citing in turn. And of course, you could always continue to explore into this topic, into this information. But at least in general, that's the situation. So basically, if you're not destroying a will, if you did not try to murder the testator, if you did not do something criminal against him or something otherwise legally punishable against him or her, you could still be declared unworthy to inherit if your behavior towards that person is found by a judge to be seriously reprehensible. And most of those cases are about the money embezzlement, about the misappropriation of money, about the mistreatment of some property. So particularly when there are many heirs, and particularly when you're basically asked to help that person, keep in mind that if you misstep, at a certain point you might be attacked, and your good deed can go punished further on. So it's important to be cautious, even if you are not there to actually steal the money of the testator. It might be seen, it might be misinterpreted that way. So whenever you administer property and money of the other person, you should remember that you're administering the property in favor of that person. And even if that person does not ask for any kind of financial report from you, keep in mind that there might be a situation when you will need to prove yourself and your good faith and that you did not misappropriate money, and to bring the documents showing how and where the money was spent. And if you're not ready to do that, then maybe you should not even take the charge, but that's your decision after all. Thank you and have a nice day.